Okay, so today we're diving into a consumer case from Thrissur, decided back in July. On the face of it, it's about a course refund. Seems simple.
Right, CC 25924. But yeah, it delivers this huge legal curveball about consumer rights when it comes to education. It's fascinating.
Totally. So let's set the scene. We have the complainants, Girija KV, who's described as a working-class laborer, and her daughter, Amrita VC.
Uh-huh. And they got interested in a diploma in fashion designing. Saw an Instagram ad from a place called Dream Zone.
The opposite party here. Now, the course fee was pretty steep, 1,50,000 rupees.
Yeah, but they didn't pay all that up front. They paid an initial 1,000 rupees, kind of like an advance.
And then another 20,000. So 21,000 rupees total handed over.
Exactly. And their claim was, look, the course never actually started. We want our 21 grand back.
Seems reasonable enough. They alleged, deficiency in service, unfair trade practice, standard consumer complaint stuff.
Well, Dream Zone's side was that Amrita decided not to join because of, quote, bad health.
Okay, so a typical he said, she said on the facts, maybe.
Sort of, but that almost didn't matter because Dream Zone threw a wrench in the works pretty early on, April 5th. They challenged the case's maintainability.
Maintainability. Okay, break that down. What does that actually mean in this context?
It basically means Dream Zone asked, is the Consumer Commission even the right place for this argument? Forget whether we owe the refund or not for a second, they argued. You've filed in the wrong type of court.
Wow. So how could they argue that? You've got an ad, a fee paid, a promise of a course. Sounds like a transaction to me.
It does to a layperson, absolutely. But the commission has to follow the law and, crucially, rulings from higher courts, like the Supreme Court.
Ah, okay. Precedents.
Exactly. And they looked at a really important Supreme Court judgment from 2017, Anupama College of Engineering.
Right, I remember that one. What was the key takeaway there?
The big one was the court stating quite clearly that education is not a commodity. It's not like buying a toaster or, a standard service.
Not a commodity. But this was a vocational course, fashion design. And they paid a fee specifically for admission and the course itself. Isn't that transactional? Especially if the service, the course, never even started.
That's the logical question, right? But then there's another layer. A binding judgment from the NCDRC, that's the National Consumer Disputes Redressal Commission.
Okay, what does it say?
This was in 2020, the Manu Solanki case. And it was even more specific. The NCDRC held that educational institutions, including those offering vocational courses,
Like this fashion design diploma.
precisely, and all activities related to education like pre-admission stuff, fees, post-admission issues, none of it falls under the Consumer Protection Act.
Whoa. So the NCDRC basically closed that door completely, even for vocational training.
It seems so. Because the complaint was about education fees and admission for this diploma, the commission concluded it just wasn't legally equipped to handle it. It was ruled not maintainable.
So the outcome was dismissed.
Dismissed, yeah. They didn't rule on whether the refund was actually owed based on the facts. They just said, we can't hear this case. They did add that the complainants had the liberty to agitate the appropriate forum for remedy.
Appropriate forum.
Oh.
Okay, so let's translate this for everyone listening. What's the bottom line here?
So the bottom line is, if you have a dispute with an educational institution, even a vocational one like Dream Zone here, about things like fees, admission, or the course itself, you probably can't use the Consumer Commission.
That route, which is often seen as quicker and more accessible, is effectively blocked based on these rulings.
Right. You'd likely need to pursue it through a different legal channel, probably a civil court.
Which, let's be honest, is often way more complicated and expensive.
Definitely. The legal status given to education here really shields the institutions from consumer complaints in that specific forum.
Which brings us to that final thought, doesn't it? The commission says go find the appropriate forum. But for someone like Girija KV, a working-class person trying to get back Rs 21,000.
Yeah, where is that truly accessible, appropriate forum? When the cost and hassle of hiring a lawyer for a civil suit might easily eat up that 21,000.
It makes you wonder if closing the consumer court door, while legally correct based on precedent, effectively leaves some people with no practical way to get their money back. A real catch-22.
A very tough spot to be in.